apprehension of anybody or that she lied. But in fact, the state's own theory to the jury in the beginning of this case was that if she did that to protect herself. That is what the state's evidence at best proved. That is not a violation of this statute. The state has alleged that the defendant hindered the apprehension of Hemi Newman through three things. One, they allege that she destroyed texts and a record of phone calls. There is absolutely no evidence in the record establishing that Andrea Sneiderman deleted anything. The state's own witness got up there and testified that a deletion could happen through any number of things. It could happen through someone intentionally deleting it. It could happen through automatic deletions over a period of time. He has no evidence whatsoever establishing or proving that Andrea Sneiderman did any such thing. The state's witness on this point also said, Your Honor, we didn't have the password. So clearly, she must have done it if it was deleted. Videotape that the state put on in its evidence established that Andrea Sneiderman handed the police detectives her password, the word Rusty, in the police interview. It is ridiculous to assert that they have proved that she deleted anything. In addition, the state's witnesses have failed to establish that the texts or phone records were evidence of the murder. Under the statute, you are only liable if you delete or conceal evidence. They have no idea what the texts contained. They had no idea what was discussed in the alleged phone records. They cannot establish beyond a reasonable doubt that that was evidence of a crime. They have failed to meet their burden of proof. The state has also failed to identify acts of concealment with respect to the texts, the romantic relationship, or her knowledge. Under the law, as we talked about a little bit yesterday, the United States Supreme Court has made clear that silence or nondisclosure is not an affirmative act. There must be some affirmative act by which someone actively conceals or destroys evidence. Throwing away a gun, hiding a gun under a bed, throwing away a pouch of drugs. Not telling someone, and again, we deny this happened, but not telling someone about the extent of your relationship with someone is not a violation of this statute. That is not an affirmative act of concealment. They have failed to meet their burden of proof. In addition, Your Honor, one of the things that you will recall is in our argument on the special demurrer, we objected very specifically to the fact that the state used a date range of November the 18th through January 5th for this offense. What's that? Nearly 7 weeks, if my math is correct. The state, in order to convict under this statute, has to establish a congruence between all the elements occurring at the same time. The statute uses the word when. You commit certain acts when you have the intent, when you have the knowledge. 7-week period. They do not know and have not proved at what point the text messages and phone records were deleted or destroyed. They have not proved that. In order to prove a violation, they must prove that that happened on a day, and at the time that that happened, Andrea Sneiderman knew or had reasonable grounds to believe that Hemi Newman had committed a murder, and that at the same time, she intended to hinder his apprehension. Let's look at the facts that the state proved. The state concedes that the very day after the murder, Andrea Sneiderman, the first time she was asked, gave Hemi Newman's name to the police. She was asked, has anybody expressed feelings in you? Yes, he has. Has he done that directly? Yes, he has. She gave that information to the police. She was subsequently blamed for waiting an hour and 15 minutes, but as you heard, this was Detective Andy Thompson's first murder investigation. That was the first time she was asked the question. She gave the answer instantly. The state of Georgia cannot establish that she knew at all times in that period that Hemi Newman was the murderer, that she intended to hinder his apprehension, and that she had that knowledge and that she had that intent at the time she supposedly deleted these messages. Hypothetically, and again, we categorically deny that she did that, and the state has not proved that she did. Hypothetically, under the indictment as alleged, texts could have been deleted on November 25th. Andrea Sneiderman could have, as she clearly did, first suspect Hemi Newman on December 28th, a month later, when she got that bizarre email from him with that iTunes song. It's a month. You can't convict somebody under this statute for intentionally hindering the apprehension of a criminal if you don't suspect them until December 28th because you deleted things a month earlier. It's not a violation. The state has failed to prove its case. In addition, Your Honor, the state, in order to prevail on its allegation that Mrs. Sneiderman hindered the apprehension of Mr. Newman by concealing the existence of a romantic relationship, they have to prove beyond a reasonable doubt that a romantic relationship existed and that Mrs. Sneiderman deliberately hindered that. The indictment in this case doesn't say anything at all about who that relationship had to be romantic to. Is the state alleging that the relationship was romantic to Mr. Newman, and Mrs. Sneiderman is in violation of the law for not disclosing that it was romantic to him?
Hold on for a second.
Yes, sir.
I'm going to let you finish, but if I'm reading this correctly, this is count one. After the comment says, concealed her romantic relationship with Hemi Newman from police, comma.
Her romantic relationship from Hemi Newman.
Right, with Hemi Newman.
That doesn't say that it necessarily that she believed it was romantic. It doesn't say that Hemi Newman believed it was romantic. That is ambiguous in our opinion, Your Honor.
I understand. Also, while you're pausing, I'm looking on page 12 of your brief, and it says romantic, it must involve sexual intercourse.
No, sir. I'm going to get to that argument in just a second.
Okay.
My point on the romantic relationship is we don't know how she defined the term because the state has failed to offer any evidence whatsoever on that.
Page 12. I went through your motion, but go
Yes,
ahead.
sir.
I'm sorry.
I'm back on page 7, Your Honor, so I'm going to stick there for just a second unless you want me to jump ahead.
No. I don't want you to jump in. It's just that caught my attention, so I was going to ask the question, but I thought we were there on romantic. But no. Go
I
ahead.
guarantee we will discuss that issue, Your Honor.
All right.
So, the state has failed to prove that there was a romantic relationship. The state has also failed to prove venue. The state's evidence established that the defendant traveled to Florida in late 2010. The date range for this offense is November the 18th through January 5th. They have to establish venue that she actually did any of these acts, which they haven't proven, in DeKalb County. They have failed to do that. Their own evidence contradicts that. Your Honor, that's count one. I'm happy to move on to count two unless Your Honor has any questions on count one.
Oh, I don't have any questions.
Okay.
The question I asked already.
Yes, sir. Count two. The defendant violated the concealment statute by concealing the existence of a romantic relationship. Again, let's talk about the standards. The code section is 16-10-20. Person who knowingly and willfully falsifies, conceals, or covers up by any trick, scheme, or device a material fact in any manner within the jurisdiction of a department or agency of state government or the government of any county, city, or other political subdivision of this state shall be guilty of a felony. State must first prove that the defendant intended to conceal a fact from the government. They have utterly failed to prove that intent. Second, they must prove that the defendant used a trick, scheme, or a device to falsify or conceal a material fact. Your Honor, their indictment didn't even allege that a trick, scheme, or a device existed. We talked about that yesterday. I don't know how you prove that something existed when you don't even allege it. They have not identified any such trick, scheme, or device. They have said she failed to tell us the whole story. Non-disclosure, silence is not an affirmative act. Third, they have failed to prove that the existence of the romantic relationship was a material fact. They did not even allege in their indictment that the fact was material. They have failed to prove that that was somehow material to the investigation. You can guess that maybe it was material if the police thought it was. They have to prove that. They offered no evidence on the point. The state must also prove that the matter that was concealed fell within the jurisdiction of any department or agency. We discussed that issue yesterday with respect to the allegations of the indictment. And in addition, Your Honor, as we discussed yesterday, under federal case law interpreting the federal false statement and concealment statute, no one can be convicted for failing to disclose something to the police unless they had a duty to disclose that information. There is no such duty present here. The state has not identified the legal source of any such duty. They have offered no evidence or testimony establishing the duty existed. That is a failure of proof on what should be an essential element of the crime. Your Honor, in addition, and we've talked about this a little bit, but I'm going to reiterate the argument briefly for the record. The existence of a romantic relationship is not a fact that can be demonstrated objectively, and if the statute is applied in this manner, we believe it is unconstitutional as applied. The statute, the indictment did not identify the person to whom the relationship must be romantic, has offered no definition of the term, and it is highly risky, Your Honor, and I believe this is why the state changed their indictment from affair to romantic, that the jurors may apply their own definition of the term to determine that the defendant violated the law by not disclosing what they believe is a romantic relationship. That is insufficient under the law. We do not know how the defendant interpreted the phrase romantic. There is no evidence in the record explaining how she interpreted the phrase romantic. The word comes up to my recollection one time. There is an email from Hemi Newman to Andrea Sneiderman in which he says, the front desk clerk says that I am the world's last great romantic. What do you do with that? Okay, romantic for sure. Great. Responds back. That's all they have. That doesn't say that romance means sex. Doesn't say romance means love. Let's talk about that for a second. What does romance really mean? Because that's what this case largely boils down to, since they're no longer attempting to argue that there was an affair. Romance usually means to most people one of two things. It can mean sex or it can mean love. There is not a single piece of evidence that the state has presented demonstrating that Andrea Sneiderman and Hemi Newman had sexual intercourse. Not one. There is not a single piece of evidence in this file demonstrating that Andrea Sneiderman ever said she loved Hemi Newman. There's not an email. There's not a testimony of any witness. Hemi Newman's...
I understand that part, but I'm just back to your definitions now. You're saying, I understand the argument. Romance must equal sexual intercourse or love.
I'm not saying that, Your Honor.
I'm sorry, maybe I missed...
No, my argument is the state has failed to prove how she interprets the phrase.
I understand that part.
The most logical interpretations typically are that it means one of those two things. Maybe it means something else. Maybe it means you have to deliver dinner to your spouse every Friday night. Maybe it means flowers every weekend. Who knows? Everybody has a different interpretation of what romantic means. In order to convict our client for failing to disclose the existence of such relationship, they must prove what she understood romantic to mean. It is undisputed that she disclosed the existence of the relationship the day after the murder. She said, Hemi Newman has expressed an interest in me. In order for them to convict her, they would have to establish she knew that that relationship was romantic and failed to disclose that fact. There is no evidence in the record establishing how she interpreted the term. The law, let's go back to the basic point. Circumstantial evidence. To warrant a conviction on circumstantial evidence, the evidence must exclude every other reasonable hypothesis except the guilt of the defendant. The state of Georgia is asking this jury to convict the defendant based on what somebody else might have determined was a romantic relationship. Our argument, Your Honor, is that they have failed to do that, and it is also unconstitutional. Your Honor, that's all I have on the concealment counts. With your permission, I'll move on to the false statement counts.
You may.
Counts 3, 5, 8, and 10 of the indictment charge the defendant with having made false statements in violation of OCGA 16-10-20. They have to prove a number of elements beyond a reasonable doubt. First, they must prove that the defendant knowingly and willfully made a false statement. Now, according to the courts who have interpreted this, that really has three subparts to it. First, they have to prove the statement was false. They have failed to do that, and we'll get to that in a second. Second off, they have to prove that the defendant knew the statement was false. Third, they have to prove that the defendant intended to make that false statement. Count 3. The allegation in the indictment is that on January 5th, 2011, the day after Hemi Newman was arrested for the murder, defendant, quote, did knowingly and willfully make a false statement in a matter within the jurisdiction of the Dunwoody Police Department, to wit. Accused told Lieutenant D. Barnes and Deputy Chief D. Sides that she never suspected that Hemi Newman was involved in the murder of Russell Sneiderman prior to December 28th. So what they're contending is she violated the law by saying to those detectives that she never suspected Hemi Newman prior to December 28th. This is taking place on January 5th. As an initial matter, Your Honor, this count fails on the grounds of a fatal variance between the indictment and the evidence. The evidence that was introduced by the state showed Lieutenant Barnes saying to our client as follows. He was asking questions about November 18th, the day of the shooting. And he said, as the day goes on and you're something in your mind, unintelligible, at any point did you ever suspect that? End of sentence. That wasn't even a full question. You can't convict somebody for making a false statement in response to something that is not a full question. He never finished the question. In addition, what he said was, as the day goes on. That was a question specifically pointed to her understanding on November 18th, 2010, not at all times between November 18th and December 28th. That is also the only time that the word suspected is used. There is a fatal variance. The next question, Lieutenant Barnes did not use the word suspected. He then said, you never thought Hemi would have anything to do with it until yesterday. And the defendant responded, up until that email. The word suspected was not used by Lieutenant Barnes. It was not used by the defendant in her answer. And the concept of suspicion and whether or not somebody would have anything to do with it are two different things. The latter is much more conclusory. It is a statement that she actually believed he would have something to do with it, as sort of suspecting that he might. The word suspicion was asked to her only about what happened on November 18th. The latter question, which related to the broader date range, didn't use that word. Under the state's case law, there is a fatal variance between the indictment and the evidence. Your Honor, I will talk in a minute about the doctrine of fundamental ambiguity, which is a federal doctrine which applies in perjury cases. But we also respectfully submit that the phrase suspected, to the extent it can form the basis for a charge, is fundamentally ambiguous without a definition of exactly what that means, and an answer to that question should not support a criminal conviction. In addition, the state has failed to proffer sufficient evidence to prove beyond a reasonable doubt that the defendant suspected Hemi Newman prior to December 28th. The sole testimony on that issue that I saw was the evidence of Shayna Citron. Your Honor, you're entitled to take the credibility of witnesses into account in determining whether or not someone has testified truthfully and whether there is sufficient evidence to take this issue to the jury. I respectfully submit that that testimony was not credible, and I would respectfully submit that even if you believe it, and even if it's correct, that her testimony that Andrea Sneiderman asked Hemi Newman the night after the murder if he had anything to do with it is a different thing from saying that she suspected that he had something to do with it. And that is the only evidence in the record on that particular point, Your Honor, that I'm aware of. The state has also, sorry.
I mean, interrupt you again, but I'm just asking. So if a person makes an inquiry, would it be possible that that person may suspect that someone may?
Absolutely. It may be possible.
It may be possible.
The standard for the code, to warrant a conviction on circumstantial evidence, the proved fact shall not only be consistent with the hypothesis of guilt, but shall exclude every other reasonable hypothesis save that of the guilt of the defendant. They must prove that in asking that question, she suspected him at that time and then subsequently made a false statement about that. They have failed to do that. The state has also failed to prove intent to make a false statement. It's important to remember the context in which this was done. This interview took place on January 5th, which was the day after Hemi Newman was arrested, some 7 weeks after the murder of Russell Sneiderman. The question was posed, when did Andrea Sneiderman first suspect him? The state's attempting to impose liability on her as to whether or not she was correct that she suspected him before or after December 28th. Murder's November 18th. December 28th is the date she got that email. January 5th is the date of the interview. How could it possibly be relevant whether she suspected Newman before or after that point to their investigation of Hemi Newman and whether he was involved in the murder? She had no incentive to lie, and they have failed to prove that she intended to deceive the police at that point. Count 5, Your Honor, is the false statement that the defendant knew that Rusty Sneiderman had been shot prior to her arrival at Dunwoody Prep. This evidence, Your Honor, is utterly insufficient to prove beyond a reasonable doubt that the defendant had that knowledge. The state has offered one piece of evidence to my knowledge on that issue, and that is the testimony of Donald Sneiderman. Mr. Sneiderman testified that Mrs. Mrs. Sneiderman, his daughter-in-law, contacted him after being called by Dunwoody Prep and on her way to Dunwoody Prep, and he claims that she said that Rusty Sneiderman had been shot. I'm so sorry. Mr. Sneiderman had a number of interviews with the police after November 18th. He said no such thing. The first time that he documented having made any such statement was coincidentally the same week that his family filed a wrongful death lawsuit against our client 6 months later.
I'm sorry, objective. There's no evidence in the record about when any civil lawsuit was filed.
Mr. Chalmers, if you could refresh my record, I know you've been here the entire time. When did that come into the trial?
I believe that was asked by one of our co-counsel about the filing of that lawsuit.
It was, and was that witness allowed to answer?
Your Honor,
as you know, because there's going to be an instruction I'm going to give to the jury. The questions that are asked by the lawyers are actually not evidence. It's what people testify to. So if you could just refresh my memory, what witness testified to that fact? Just refresh my memory.
Candidly, Your Honor, I'm not sure whether he testified to that fact as not. No. So I'll withdraw the argument then, Your Honor.
Oh, okay. That's fine.
I'll withdraw it.
But if you want to, I'll sustain that.
If there is in fact evidence, I don't remember whether he testified to it or not. Was the objection sustained?
The objection was sustained. I do not believe there was any actual testimony in regards to what Mr. Chalmers has stated. No.
My apologies, Your Honor. I withdraw the argument.
No, I'm just responding to the objections. You objected?
Understood.
All right, go right ahead.
But by the same token, even if you accept at face value what Mr. Sneiderman said, that is insufficient to prove beyond a reasonable doubt that our client had that knowledge. It's the only evidence on the subject. You've got basically a classic case of two contrary versions of the same phone call. In that circumstance, you can't prove beyond a reasonable doubt which one of them was telling the truth. There is a case, Your Honor, from 1909 from the Georgia Court of Appeals, Bell versus State, which we've cited in our brief. It is unsafe to convict in any case where the oath of merely one man has to be weighed against that of the other. The equilibrium of the evidence must be destroyed by material and independent circumstances before the jury would be authorized to convict. Now, in Bell, that was a perjury case, and they were talking about the two-witness rule, which we'll get to in a second. There is, under the false statement statute, not the same rule as a matter of law. As a matter of law under perjury, you may not convict somebody in the absence of two witnesses or one witness plus strong independent corroboration. That doesn't exist by statute in the false statement statute. We respectfully submit that that common law rule, which has formed the basis of that statute, should be applied equally well to the false statement statute. Even if it is not, the testimony of one man versus one woman is insufficient to convict somebody beyond a reasonable doubt. Count 8. The defendant made it clear to Hemi Newman that she did not want him to pursue her romantically. It is alleged that in her interview on November 19th, the defendant lied when she said that, supposedly, to Defendant Thompson. There is a fatal variance, Your Honor, in the indictment and the evidence. The audio tape of the interview on November 19th makes it clear that she did not say any such thing. The defendant was asked, after Mrs. Greenberg, the defendant's mother, prompted the police to ask her whether or not Mr. Newman's feelings for her were reciprocated, our client said no, and I made that clear. In other words, she said that her feelings for him were not, his feelings for her were not reciprocated. The word pursue was not used. The word the word romantically was not used. There actually is a later point in the tape where the defendant is letting Bonnie Greenberg talk, and she actually says at one point that Andrea had said to her that she did not want Hemi Newman to pursue her. That was Mrs. Greenberg's statement. That was not Andrea Sneiderman's statement. You can't convict somebody for a false statement for something said by somebody else. So there's a fatal variance. In addition, I want to point out to the court that in its opening statement, the state asserted to the jury that the defendant began to feel conflicting feelings. She would be interested in Mr. Newman, but then she'd pull back and she'd say, "We can't do this." The state told the jury that the defendant said, "We can't do this." The evidence has also established that she clearly told Hemi Newman she would never divorce or leave her husband. To the extent the state is claiming that she lied by saying that she did not want him to pursue her romantically, why are they telling the jury that she told Hemi Newman, "We can't do this"? There is no proof to satisfy the allegation that she lied by saying that she did not want Hemi Newman to pursue her romantically. Count 10, Your Honor, is a false statement charge again. The defendant denied that Hemi Newman was in Longmont, Colorado with her. Let's read the allegation. On January 5th, the day after the murder, defendant, quote, did knowingly and willfully make a false statement to Lieutenant D. Barnes and Deputy Chief D. Sides, to wit, she denied that Hemi Newman was in Longmont, Colorado in July 2010 with the accused. The tape of that interview that the state played, in it, Lieutenant Barnes says Hemi was not in Denver. The defendant answered that question. She then asked for clarification on the question, which was not provided. There is a fatal variance in the allegations and the evidence. I would point out to you, Your Honor, that in the state's case, Detective McManus from Longmont, Colorado testified that it is approximately a 1-hour drive from Longmont to Denver. That is in evidence in the case. They are different cities. They are far apart. In Thrasher v. State, 292 Georgia Appeals 566 of 2008 case, we had an allegation of a DUI and failure to maintain lane. Went to trial. The state charged the wrong road in the intersection, and the Court of Appeals concluded that that was a fatal variance. The wrong road of an intersection. These are two cities 40 miles apart. Clearly, if the wrong road in an indictment is a fatal variance, the wrong city is as well. In Dixon versus State, Your Honor, and there are other cases as well, the court entered a directed verdict of acquittal on the grounds that the state misnamed the store that the armed robbery apparently or allegedly occurred at. There's a fatal variance in this count, Your Honor, and it must be dismissed on that ground. Your Honor, we've already previously argued the materiality issue. I told you about Banta versus State that the Supreme Court disagrees. I'm not going to repeat that argument here today. Your Honor, I'll move with your permission. I will move on to the perjury counts.
You may.
Okay. Thank you, sir. The elements of defense of perjury under 161070, a person to whom a lawful oath or affirmation has been administered commits the offense of perjury when, in a judicial proceeding, he knowingly and willfully makes a false statement material to the issue or point in question. The elements of that offense, which the state must prove beyond a reasonable doubt, are the defendant knowingly and willfully made a false statement that was material to an issue in question in the previous judicial proceeding while under oath in that proceeding. I think it's important, Your Honor, to remember a little bit about what the law on perjury involves. There are very few perjury cases in Georgia. I don't think that there are many cases where the district attorney anywhere in the state has brought a perjury indictment on the grounds that somebody lied about kissing somebody else. I think in light of that, we need to go through this a little bit. The offense of perjury consists in swearing falsely and corruptly without probable cause of belief. Thus, both the intent to testify and the act of false testimony must be shown as elements of the crime. Excuse me, Your Honor. The state must also prove that the testimony was material to an issue in the previous proceeding. Falsely swearing to an immaterial matter is not an indictable offense. There is also in the law, as we discussed very briefly before, a codification of the common law rule that perjury may not be based on the testimony of solely one witness. There must be, under the law, and this is 2414-8 under the new evidence code, it was 2444-8 under the old evidence code, the testimony of a single witness is generally sufficient to establish a fact. However, in certain cases, including prosecutions for perjury, the testimony of a single witness shall not be sufficient. Nevertheless, corroborating circumstances may dispense with the necessity for the testimony of a second witness, except in prosecutions for treason. The reasons for this rule, long-standing rule, are very clear. The ancient rule of the common law required the testimony of two witnesses both directly contradicting the testimony previously delivered by the prisoner in order to authorize a conviction. The reason assigned being that the testimony of one witness would merely be one oath against another. So what is the level of corroboration that must be established? That was laid out in In Re CH, Your Honor, 262 Georgia Appellate 630. The corroborating evidence must be both independent of the one witness, and it must also be strongly corroborative. The word strongly corroborative it had its origins in 1909 in Bell versus State, or that phrase did. It was repeated in 2003. It's a long-standing rule. In addition, and this is also important, the state may not rely on allegedly contradictory statements made by the defendant as the corroborating evidence. Dixon versus State, 172 Georgia Appeals 803. A conviction for perjury requires either testimony of two witnesses or that of one witness and corroborating circumstances to support it. The proof that the defendant had made contradictory statements is not alone sufficient to convict. Moreover, and this is important in perjury cases, when we speak of corroborative evidence, we do not mean evidence that emanates from the mouth of the defendant himself, but evidence aliunde which tends to show the perjury independently of his own declaration. The state has failed to comply with that rule with respect to a number of these counts, as we will discuss in just a moment, Your Honor. First off, the very first one. Count 4, perjury that the defendant did not know that Russell Sneiderman had been shot when she spoke to Donald Sneiderman. Again, the only testimony that has been offered that I'm aware of in this case that Andrea Sneiderman supposedly knew that before she got to Dunwoody Prep is the testimony of Donald Sneiderman. Setting aside any issues of witness credibility, this is an issue as a matter of law that is insufficient to establish the falsity of the defendant's statement, and the absence of independent, strong corroboration showing some other fact that shows Andrea Sneiderman's knowledge before she got to Dunwoody Prep, that count fails as a matter of law. Count 6, Your Honor, perjury. I'm sorry, did you have any questions or should I keep going, Judge?
Keep going.
Yes, sir. In addition, also, Your Honor, the state has failed to prove how that allegation or how that allegedly false statement was material to the trial. Count 6, perjury. The defendant was not romantically involved with Hemi Newman. The question that was posed to the defendant by the state, the prosecutor, was, were you and the defendant romantically involved? Your Honor, there is a doctrine under federal perjury law that applies perfectly to that type of a question, and it is the fundamental ambiguity doctrine. The 11th Circuit has described the doctrine in a number of cases. This court has held that when a question is arguably ambiguous, the defendant's understanding of the question is a matter for the jury to decide. Both parties agree, however, that when a line of questioning is so vague as to be fundamentally ambiguous, the answers associated with the questions posed may be insufficient as a matter of law to support a conviction. The reasoning of the 11th Circuit in the Manapat, I don't know if I'm pronouncing that case right, 11th Circuit 1991, Your Honor, which is cited in the brief, is particularly instructive, and I would like to read it into the record. We find the reasoning in the Lattimore case useful in addressing Manapat's argument. In Lattimore, the defendant was indicted for perjuring himself before a Senate subcommittee when he denied he was, quote, a follower of the communist line. The court dismissed the indictment, holding that the phrase was too vague to support a conviction. The court stated as follows: this count, even with its apparent definition, is an open invitation to the jury to substitute by conjecture their understanding of the phrase for that of the defendant. To ask 12 jurors to agree and then decide that the definition of the communist line found in the indictment is the definition that the defendant had in mind and denied believing in is to ask the jury to aspire to levels of insight to which the ordinary person is incapable and upon which no such speculation, a criminal indictment, should hinge. That reasoning applies exactly to the question, were you romantically involved with the defendant? In the absence of a definition of what the word romance meant, there is no way that this would be constitutional to allow the jury to make a determination about what romance means, which definition of that term she meant, and that she lied when she denied it. Your Honor, as we've talked about before, the state has offered no evidence whatsoever establishing how the defendant interpreted the phrase, and therefore there is insufficient evidence. And just so I'm being clear, the fundamental ambiguity doctrine is a matter of law. If the question was fundamentally ambiguous, it does not go to the jury. We are making a second argument as well, and I sort of merged them, and I want to make it clear to the court. The second argument is that they have failed to offer sufficient evidence on how she interpreted the phrase romantic to prove their case. We've talked about that, Your Honor. I won't repeat it.
All right, you've made it clear.
Count 7, perjury. None of Hemi Newman's feelings were returned. If there's ever a case where the fundamental ambiguity applies, feelings being returned is it. First off, the state would be required to prove that, in order to prove perjury, that the defendant believed that Hemi Newman had expressed certain feelings to her and that she had, in fact, returned those feelings. The evidence in this case established that Hemi Newman said, "Marry me," that he expressed his love for her. There is not a single piece of evidence establishing that Andrea Sneiderman ever said she loved Hemi Newman or that she returned his feeling of "marry me." Honestly, we have no idea what feelings were being referred to there at all.
Now, I understand your point. It says to wit that none of Hemi Newman's feelings for her were ever returned, such statement being material to the issue surrounding murder of Russell Sneiderman.
Yes, sir.
None of Hemi Newman's feelings for her were ever returned.
What feelings are we talking about? The state has failed to prove that.
Now, I don't know. I mean, I was
Me neither.
just making an argument. But let me ask you this. There was a witness, and I'm going to use the general term, the South Carolina situation in which I think the witness may have relayed that from her vantage point that these people kissed. Mm-hmm. If people are in, well, the length of the kiss may become material at some point, but if people are embracing or kissing, would that, well, could that be interpreted as returning feelings if you are kissing someone? And I understand even kissing may be subject to interpretation because body parts have to come together. And one may be more aggressive than the other, so I understand.
Your Honor, the evidence that the waitress from Greenville, South Carolina proffered was that there was apparently a pop kiss, which is a term of art in Miami. I'll have to go down there because I don't know what that means. I don't know what a pop kiss is. And the fact that somebody gives a pop kiss, I don't know what that, I don't know how you then go from a kiss or a pop kiss or any other kind of kiss to establishing that there were feelings. I don't know how, as a matter of law, you can put somebody in prison for the proposition that because there was a kiss, there necessarily were feelings. We can interpret what those feelings or deduce what those feelings might have been. We can deduce that not only were there feelings, they were mutual feelings, and that in fact those feelings were returned somehow. In addition, Your Honor, when we get to the waitress, that charge goes out the door because there is only one witness testifying to that supposed kiss, and the two-witness rule has been violated. We'll talk about that in just a second. But I respectfully submit they have failed to prove that Hemi Newman had feelings for Andrea Sneiderman that she returned. In addition, Your Honor, it's worth pointing out that to the extent the state is attempting to prove that Andrea Sneiderman returned those feelings through her own statements, that is a violation of Dixon. The corroborating evidence cannot be the witness's own statements. Count 9, perjury, and also, Your Honor, I'm sorry, on that account, they have again failed to prove how that statement was material in the Newman trial. Count 9, perjury. The defendant is charged with perjury for stating that she did not share a hotel room with Hemi Newman in Longmont, Colorado. The state did not introduce any evidence establishing that they were ever seen in the room together. They did not introduce any evidence establishing that Mr. Newman was seen at the hotel by any of the personnel. They did not establish that Mr. Newman had a reservation at some other or did not have a reservation at some other hotel. They checked within a 5 to 7 mile radius and found nothing, which means nothing. And the only record that the state introduced that suggested there were two people in the room covered a time period in which Mr. Newman wasn't in Longmont, Colorado. And I'm taking that directly from Mr. Clegg's analysis of his witness on that point. The record that established that there might have been two people in the room covered the time period July 18th through July 20th. The flight records showed that Mr. Newman arrived July 21st, stayed through July 23rd. To warrant a conviction on circumstantial evidence, the proved fact shall not only be consistent with the hypothesis of guilt, but shall exclude every other reasonable hypothesis save that of the guilt of the accused. State has failed to offer anywhere near sufficient evidence to prove that Hemi Newman and Andrea Sneiderman shared a hotel room and that she then lied about that fact. Count 11, perjury, that she believed, Andrea Sneiderman believed that Hemi Newman was in Longmont on business. Your Honor, may I just have a moment to confer with counsel?
Oh, yes, sir.
Just 1 minute.
As much time as you need.
Thank you, Your Honor. Apologize.
All right, Ms. Carpenter, we're back on the record. Oh, no problem.
The only evidence that the state offered on this point, Your Honor, was the testimony of defendant herself from the perjury trial. I'm not perjury trial, I apologize, from Hemi Newman's trial. As I recall, the state introduced a tape of Don Geary, former Chief Assistant District Attorney, questioning the defendant and asked her whether or not an email from Mr. Newman suggested that he was not there, or that he was not there on business. That is the only evidence they have to prove that she committed perjury. It is her own statement. You cannot convict somebody of perjury based on contradictory statements. There must be two witnesses to establish the falsity of the statement. The state has failed to meet its evidentiary burden on that. Count 12, perjury. The defendant lied when she said that she did not kiss.
On that point.
Yes, sir.
I can't see them because aren't are emails in front of this, were they introduced from Mr. Newman also during this trial?
Yes, sir.
Okay, so they may be up there. So emails, it's a binder of emails, is that correct?
Lots of binders of emails, Your Honor.
Right. And some of them may be from Mr. Newman.
Some of them may be from Mr. Newman. This email was, in fact, from Mr. Newman. But the state is alleging that the evidence that she committed perjury was her testimony in the trial where Mr. Geary asked her, does that say that he's not on business? And she conceded that.
Oh, no, I understand it, but the point I was making when you said it's not, I'm not saying it is, but I'm saying if all, it may not even be in front of me, but if all of Mr. Newman's emails are in evidence,
Yes, sir.
quote unquote, that may be evidence that supports what was asked by Mr. Geary.
It can be used, Your Honor, but it still has to be sufficient corroboration. If, in fact, they were relying on the defendant's own statements that are contradictory, they can't rely on that to prove perjury. If, in fact, they're relying solely on Mr. Newman's emails, we haven't had an opportunity to cross-examine. We would respectfully suggest, Your Honor, that that evidence is alone insufficient to prove beyond a reasonable doubt that the defendant lied about anything.
Well, I'm not, that wasn't my point, but I think there was a stipulation on those emails, I thought.
Stipulation, yes, sir, that they're authentic.
That they're authentic and they've been admitted in the evidence.
Yes, sir, that's correct.
All right, you may continue.
Count 12, Your Honor. The defendant is charged with lying by stating that she and Hemi Newman did not kiss while in Greenville, South Carolina. The sole evidence that's been offered on this kiss is the testimony of Christine Oliveira, who testified about the pop kiss. As a matter of law, that is insufficient to establish the defendant kissed Hemi Newman in Greenville, South Carolina, and then lied about it. As a matter of law, evidentiary rule. And finally, Your Honor, on the perjury count, the defendant did not immediately report her suspicions about Hemi Newman because of her mother's concern for her safety. There is a fatal variance. Mrs. Sneiderman did not state in the testimony that was introduced by the state that that was the sole reason that she did not report her suspicions immediately to the police. Constitutional challenges, Your Honor. I am not going to spend a lot of time on these. I know the court has read the brief, but there is one or 2 points I'll make, and I'll take less than 5 minutes on this, if I may, Your Honor. In the United States versus Alvarez last year, the Supreme Court issued a very important opinion that relates to statutes which attempt to criminalize speech or statements. That statute, the statute at issue in that case was the Stolen Valor Act, which is a federal statute which makes it a crime to claim that you have won the Medal of Honor. In both the concurring opinion by Justice Breyer, with Justice Kagan joining, and the dissenting opinion by Justice Alito, with Justices Scalia and Thomas joining, they all emphasize the importance of the fact that the statute, quote, applies to only a narrow category of false representations about objective facts that can almost always be proved or disproved with near certainty. Georgia applies that same basic rule in defamation cases. You cannot assert a defamation case based on someone's opinion. That is a matter of law, and the reason for that is the reasons for that are various, but they apply equally well to a criminal case. They actually apply even more stringently in criminal cases where you're not attempting to pose civil obligations, but to put somebody in jail. You may not criminalize someone for failing to disclose their opinion about whether a relationship was romantic. In addition, in the Thornton case, 2009, the court concluded that when a defendant's words can, by definition, be used to demonstrate either one fact or another, and the defendant's statement would only be false if it refers to one but not the other of those facts, then as a matter of law, the state cannot prove beyond a reasonable doubt that the defendant made a false statement. Finally, Your Honor, in its recent decision this year, in Malloy v. State, the Supreme Court noted that in determining whether, for the purpose of a vagueness challenge to a statute, the defendant had sufficient notice of the prohibited conduct, a court should review the state's allegations of facts as recited in the indictment coupled with the applicable law. You don't just look to the language of the statute, you look to how it's being applied in the case. A number of the counts in this case fail to satisfy those required standards of objectivity. Counts 1 and 2 relate to, again, concealing a romantic relationship. Criminal liability may not be imposed on the basis of such vagaries. Count 3 alleges that the defendant lied when she said, supposedly, that she never suspected Hemi Newman prior to a certain date. That term, suspected, and the question of whether a person held a suspicion is inherently vague, ambiguous, subjective, and not a fact capable of objectively being proven true. The same thing applies for Count 6 with its use of the term romantically involved. Count 7, contending that the defendant committed a crime by falsely asserting that someone's feelings for her were not returned. Count 8 alleges that on November 19th, the defendant made a false statement that she had made it clear to Hemi Newman that she did not want him to pursue her romantically. We respectfully submit, Your Honor, that the state of Georgia is again attempting to create some very new and very bad law in this state. They have failed to prove their case beyond a reasonable doubt, and we respectfully request that the court grant the motion.
All right, thank you, Mr. Chalmers.
Yes, sir.
All right, before I hear the state's response, Deputy Garrett, let's take about a 6-minute stretch break.
All rise.
You may be seated.
Welcome, everyone, to 11 Alive's continuing coverage of the trial of Andrea Sneiderman.